Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court justice. With me, Jill Barton. Today, our AI hosts take on pronouns, those small words that can cause big confusion. We'll talk about how to use pronouns clearly and inclusively, so your writing stays both precise and respectful. Let's listen in.
Have you ever been, drafting a brief or maybe even just an email and you just kind of freeze over one word, a pronoun?
Oh, absolutely.
You're just staring at it thinking, okay, do I say they, is he or she? What about a company? Is that an it? Or maybe a they?
Yeah, if that sounds familiar, you are definitely not alone. It's a really common challenge in legal writing.
And honestly, it feels like a subtle minefield even for people who've been doing this for years.
It really is. We tend to think of pronouns as these small functional words, right?
Mm-hmm.
But they pack an incredible punch when it comes to clarity and precision and, yes, inclusivity.
Yeah.
You get them wrong, and you risk confusing your reader. Or worse, you might unintentionally alienate someone.
Right. And getting that right, navigating it correctly, it feels like it's become pretty much non-negotiable for modern legal writing.
It really has.
So for this deep dive, we've pulled insights from the Supreme Guide to Writing by Jill Barton. And we're going to focus specifically on her chapter, her own deep dive into pronouns. We want to give you a shortcut, basically, a shortcut to understanding how the highest court in the land thinks about and, actually uses these tricky little words.
Well, the main principle is right there at the beginning. Choose inclusive and clear pronouns.
Inclusive and clear. Sounds simple enough, right?
Well, yeah, but it immediately bumps up against the very nature of pronouns. The guide puts it really well. It says they're a form of shorthand that by their nature too often fail to fully stand for what they're describing.
Ah, okay. So they can create ambiguity just by being shorthand.
Exactly. And as the guide points out, gender pronouns specifically, well, they can offend and exclude individuals who are non-binary or whose gender is undisclosed or unknown.
It's pretty striking how the guide sets the stage for this. I mean, it seems like a small grammatical point, but it kicks off with these really profound ideas. It opens with that powerful quote from Justices O'Connor, Kennedy, and Souter about the heart of liberty being the right to define one's own concept of existence.
Wow. Yeah. And then it immediately pivots, doesn't it, to the literary world.
Yeah.
With that quote from the French lieutenant's woman.
Right. I say her, but the pronoun is one of the most terrifying masks man has invented.
Terrifying masks.
Yeah.
It really lands the point, doesn't it? Even in the, very controlled world of legal writing, these little words carry so much weight.
They really do. Okay, so let's actually unpack what the guide tells us. How do the Supreme Court justices themselves grapple with these terrifying masks in their own writing?
Okay, let's dive in. What the guide does is analyze the justices' opinions, their actual writing, to figure out their practices. And it reveals some pretty clear rules, but also some areas that are, well, still evolving. Okay, rule 1. This is about referring to specific individuals in a case. The overwhelming practice, now the guide calls it, a 7-2 majority rule, based on their analysis, is to use their correct personal pronouns. And it's a relatively recent shift, but a really significant one. The guide points straight to the Bostock case from 2020. The landmark LGBTQ plus rights decision.
Right. And Amy Stevens, one of the plaintiffs, she was a transgender woman.
Exactly. And the 6th Justice majority opinion, the one written by Justice Gorsuch, it consistently used she when referring to her.
Okay.
But what's really revealing, and the guide highlights this, is the contrast with the brief from the funeral home opposing her.
Oh, right. They actively avoided using her correct pronouns, didn't they?
They did, yeah. But they also specifically mentioned following a previous case's lead to, quote, avoid use of pronouns in sex-specific terms when referring to Stevens.
Wow. That sounds very deliberate, like trying to avoid acknowledging her gender identity through language.
It reads that way, yeah. But then fast forward just 3 years, you get the Santos Zakaria v. Garland case. It involved another transgender litigant, Estrella Santos Zakaria.
Okay, and what happened there?
Well, not only did the court majority use her correct pronouns, her, but get this. The guide reveals that all 10 briefs filed in that case use her correct pronouns. Every single party, every amicus brief.
All 10. Wow. Okay, that really shows how quickly this practice is becoming standard.
It really does seem that way. Now, the guide is careful to note Justices Alito and Thomas didn't actually use pronouns for Ms. Santos-Acaria in their concurrence in that case. And Justice Alito had expressed concerns about pronoun usage back in his Bostock dissent. So their specific practice hasn't explicitly adopted this yet in opinions when they refer to the individual. But the key insight here, backed up by the guide's analysis of the actual opinions, is that the prevailing practice of the court when ruling for an individual who uses specific pronouns is to use those pronouns.
This is just part of modern, respectful legal writing now.
Exactly. Okay, so let's shift gears a bit from specific individuals to generic ones. A person, an applicant, the consumer. Here, the guide reveals a practice that's actually been unanimous at the court for a long time. They've abandoned using he as a universal catch-all.
The old generic he. Yeah, that feels pretty dated now.
It is, and this is where it gets really interesting, because the guide doesn't just say, don't use universal he. It shows how the justices actually avoid it, and it's not always the way you might first think.
How so?
Well, one method is simply rotating between he and she for generic examples. Although, as the guide points out, some older examples can still kind of fall into those gendered stereotypes.
Right, like the criminal is always he and the victim is she. You still have to be mindful of that unconscious bias, even if you're trying to rotate.
Absolutely.
Yeah.
But what the guide highlights as a much more prominent and seemingly deliberate practice is the routine use of feminine pronouns for generic individuals.
Okay, that's a powerful insight. They don't just rotate 50-50, they seem to actively use she for abstract examples.
Yes, and the examples the guide pulls out are fantastic. They really stick with you. Like the customer ordering ceviche, would she expect it to be cooked? No. Or the programmer determining which integer is larger as part of her program. The expert witness who must produce all data she is considered. The Maine citizen whose land gets polluted, she sues the company.
Okay, those examples make it crystal clear. Using she for generic individuals isn't accidental. It seems like a conscious choice by the justices to move away from that historical default of he.
It really does seem that way. Another unanimous tactic they use is simply making the references plural for hypotheticals.
Oh, right. So instead of saying an applicant may be less likely, you'd say something like, applicants may be less likely to engage if they fear those activities will subject them to private suits.
Exactly that. Or maybe it would be necessary for the individuals in question to believe that, might engage in conduct that harmed them. It's a really simple, kind of elegant workaround. You avoid the whole singular gender pronoun debate entirely for those generic cases.
Makes sense. This means using he for a generic person is clearly outdated. Just avoid it.
Right. Now let's tackle the big one, the singular they. This is probably one of the most debated pronouns in modern English right now. And the guide shows it's a point of fascinating tension, even at the court.
Yeah, the guide addresses this in two different sections, right? It presents it as both an undecided rule and a unanimous rule, which sounds kind of contradictory at first. Let's break that down.
Right. So the undecided part, that's section 26.4. It's about whether the court will use the non-binary they when referring to a specific individual involved in a case, someone who actually uses they-them pronouns.
Okay.
As of the guide's publication, the court hadn't actually faced this exact scenario in a written opinion.
So they hadn't had a case yet where a party specifically identified themselves using they-them and it needed to be addressed in the opinion.
Correct. But the guide argues pretty compellingly that it's almost certainly coming. I mean, given the court's adoption of using individuals' correct personal pronouns in Bostock and Santos-Acaria.
The logical next step when they do get a case with someone using they would be to use they.
Exactly. That seems to be the trajectory. And lower courts are already doing this. The guide highlights that Seventh Circuit decision from 2022 involving an appellant named Dijak.
Oh, yeah. What did they do?
Well, the Seventh Circuit explicitly used they-them there for Dijak. And they cited Bostock as justification, noting the, quote, emerging consensus for this usage in major style guides and dictionaries.
Okay, that's a pretty strong signal from a federal appeals court.
It is. So using they for a specific person who uses those pronouns, not yet seen in Supreme Court opinions, but seems likely given the trends.
But what about the unanimous part?
Right, that was section 26.5.
Yes. And this is a really key insight for your formal legal writing. The justices unanimously avoided using the singular they in their written opinions when they were referring to generic individuals.
Okay, so they might use it in conversation, like during oral arguments?
Exactly. The guide notes that. You'll hear justices say things naturally like, so why can't an employer tell an employee what they're permitted to do? Or ask about the person who wrote this language and why they wrote this language. It flows fine in conversation. But it doesn't make its way into their formal written opinions when they're talking about, say, a hypothetical person or a confidential source.
Correct. The guide's analysis shows they stick to the traditional grammatical standard in their writing. They seem to view the singular they for a generic person as potentially confusing singular and plural.
Okay, so the critical takeaway here for you, the legal writer, is...
Well, be aware that singular they for individuals who use those pronouns is gaining rapid acceptance. Lower courts are using it, style guides endorse it. However, in your formal legal writing, like briefs or memos, the Supreme Court currently avoids using they for generic individuals. They prefer the other methods we talked about, feminine pronouns, plurals.
Okay, let's move to Rule 3, Section 26.6, collective nouns. The guide says this is a unanimous rule.
Yeah, this one's pretty straightforward and consistent. Collective nouns, single words for a group like court, company, committee, parliament. They take singular pronouns it, itself, its in Supreme Court writing.
Even though they represent, like, many people or entities?
Doesn't matter. The practice seems firm. The guide gives plenty of examples. The court says it does. Parliament finally relent its actions. Singular it is the rule.
Okay. The guide does point out, though, that this can sometimes feel a little awkward, right? Especially with certain collective nouns like team. You instinctively want to say they.
You do.
Yeah.
And the guide's insight here is just brilliant. How do the justices handle that potential awkwardness?
Now.
Not by using they, but often by writing around it. In that case, about the high school coach praying with the team, the guide notes the word team appeared 44 times across all the opinions. But a pronoun for team was never actually used, not once.
Wow. 44 times and no pronoun. That really shows commitment to the rule. They'd rather rephrase or just omit the pronoun than break that singular it rule for a collective noun.
Seems like it, exactly. The guide mentions a historical quirk. The Constitution itself uses they for Congress. But the modern unanimous practice in court opinions is singular it.
Okay, got it. Rule 4, Section 26.7, who versus whom. This one is notorious. It trips so many people up.
It really does. But the guide gives us certainty here.
Okay.
It confirms the justices consistently use whom correctly. And it really just boils down to a simple rule. Who is for subjects, whom is for objects.
Right, like he is the subject, him is the object.
Exactly. And the guide offers that fantastic mnemonic trick.
Okay, remind us how you apply that.
So you use the substitution method. If you're stuck between who or whom, just mentally swap in he, him, or they, them. If he or they fits grammatically, you need the subject form, which is who. If he or them fits, you need the object form, which is whom. That ending on him and them reminds you it pairs with whom. Just ignore her for this trick. It doesn't fit the M pattern.
Okay, let's try the guide's examples. Director, whom the president could remove.
Substitute. The president could remove him. Him works, so it's an object. Use whom.
The trick really does help clarify. And the guide gives another easy indicator for whom, right?
Yes, if whom comes right after a preposition like about whom, for those whom, none of whom, it's the object of that preposition, so you always use whom there. Easy peasy.
Now, the guide does note that even though they use it correctly, the justices seem to use whom less often than who.
Yeah, it suggests they might sometimes just write around it. I mean, while mastering whom definitely adds precision, the guide kind of hints that maybe favoring slightly plainer language sometimes wins out over using a word that can sound, well, a bit formal or even pompous to some ears.
But the key insight is they know the rule. They use it correctly when they use it, demonstrating that command of the language.
Exactly.
So for your writing, knowing this rule, even if you occasionally rephrase to avoid sounding stiff, it's still a mark of precision and skill.
Definitely. Okay, finally, Rule 5, Section 26.8. Pronouns for ideas. This is about using words like it, this, or that to refer back to abstract concepts or arguments or maybe sets of rules.
Right. And traditional advice sometimes warns against doing this, right? Because it can be ambiguous.
It can be. But here's where it gets really interesting again. The guide's insight is that the justices absolutely use these pronouns for ideas, and they do it effectively.
So they do use it and this as shorthand.
Yes, for complex concepts that they've just explained. The key, though, according to the guide and what you see in their practice, is that the antecedent, the idea the pronoun refers back to, has to be spelled out crystal clear right before in the immediately preceding sentences or maybe paragraphs.
Context is everything. The guide's example from Chief Justice Roberts seems perfect for this. He uses this to summarize several paragraphs detailing what was it? A federal law, a state law, and a tribal resolution about gambling. It avoids being super repetitive and wordy, but it maintains clarity because the context is so fresh in the reader's mind.
Precisely. It's like the ultimate legal writing shortcut, right? Like, it is so ordered.
Okay.
At the end of an opinion, summarizing maybe 50 pages.
Okay, so using pronouns for ideas, it's actually a tool for being concise, as long as the thing it refers back to, the antecedent, is totally unambiguous.
That's the catch. The problems happen when that pronoun could refer to multiple things, which, let's be honest, happens a lot in complex fact patterns with lots of players. And the guide offers this masterful solution from Justice Sotomayor's writing.
Oh, right. Her description of the Andrus family facts, there was Terrence Andrus, his 4 siblings, his mother, her boyfriends, lots of potential for he or she or they to get completely lost.
Totally confusing potential. Yeah. But the guide analyzes how she handles it. She uses pronouns for Andrus, his siblings, and his mother, sure, but only immediately after mentioning them by name or role in the same sentence.
Proximity.
Exactly.
Oh?
By putting the pronoun right next to the person it refers to, like Terrence Tremaine, Andrus, she makes it absolutely clear who's who. The guide counts something like 20 pronouns clarified across just 3 sentences using this strategy. So there you have it. That was our deep dive into Supreme Court pronoun practices. Think about this. How much responsibility do you have in adopting clear, inclusive practices? How much can your writing help shape the future conventions of legal language?
Pronouns are small, but carry great weight. Clear, inclusive pronoun choices help you avoid confusion and show respect for your reader. Tune in next time to hear how the justices improve the flow and organization of their writing with transitions. And remember, you can be a great legal writer.